Only the attorneys that are arguing are sitting up front. Stand, they have questions to represent as well. So those are back here.
Gosh, whenever you're ready.
Excuse me, Your Honor?
Whenever you're ready.
Oh, I appreciate that. May it please the court, I'm Shagret Doss, I'm the appellant. And the issue for the court.
Before you get in, would you like to reserve any time for rebuttal?
Yes, Your Honor, I apologize. Yes, I'd like to reserve 5 minutes for rebuttal. I don't know how they're going to break this up, but we'll figure it out as we go along. It's kind of simple for this case, even though it's built on another action, that the trial court abuses discretion when it didn't allow me an opportunity to amend my complaint in this case. And apparently the trial court relied on not only misconduct, but a total misrepresentation of the facts of the underlying case, and also ignored the evidence in the documents that were submitted. The release that was signed under duress, and the trial court also took jurisdiction over unpled issues. So that's where we are today. I would think I need to tell the court that I also filed a motion to vacate the underlying orders because as we've gone along, I've discovered that the trial court operated without jurisdiction in a couple of instances, particularly over the parties that were not represented in the mediation settlement agreements at the second mediation hearing, settlement conference. So it's a little bit interesting. But to this case solely, the trial court just abused its discretion. They couldn't tell me I couldn't amend the complaint. Moreover, none of the parties filed a response to pleading. They just filed motions to dismiss.
Well, that is permissible.
But they didn't.
For the court to dismiss prior to a response to pleading.
Right, but they didn't address any of the underlying issues, Your Honor.
Well, that's what a motion to dismiss. The motion to dismiss is confines the court's analysis to your complaint, and it presumes that everything that you pled is true, and then based on that presumption, determines whether based on the law you've stated a claim. So you would, and then so that it is permissible under the rules for a trial court to dismiss a case prior to an answer being filed.
I understand that, Your Honor, but the issue still is, even if they wanted to dismiss it, they couldn't say, well, you can't amend your complaint.
So then you would need to contend, I mean, I'm predicting, because I've read the briefs, I'm predicting what your opposing counsel is going to say. You need to contend with the reasons that support a denial of amendment, and that would be futility. So in other words, if the court could credibly come to the determination that it's futile to amend, and that then it's permissible for a court to deny amendment. And they're going to argue that, and I know that because I've read the briefs, that there was a settlement agreement that barred your action. And also there's what's called the litigation privilege.
Now, Your Honor, talk about litigation privilege, because of the criminal activity that was engaged in by the opposing counsel, and although there are several counsels here, the only counsel that was available for the underlying case was the firm Austin Rowan Baskel. Where these other people come from, I don't know. None of them appeared at the mediation settlement conference, and none of them ever filed any appearances into the record to state that even Austin Rowan Baskel had the authority to represent not only Dr. Shim Spine, the United States government, and I guess he has some sort of relationship with State Farm, but he sprinkled all these people in, and this is our second settlement conference. I wouldn't even have attended had I known about all the other underlying issues. He really just had the second mediation conference as a way to create some sort of subterfuge for allowing them to escape the criminal activity. You have a VA doctor that saw me for State Farm first.
Mr. Doss, the request, to go back to one of your issues, the request that you made to amend, is that at the hearing where we don't have the benefit of a transcript?
Right, and I'm glad you brought that up,
And
Your Honor.
do you understand that we don't know what happened without the benefit of a transcript.
Right, Your Honor, and that was kind of interesting because one of the attorneys hired, I've always had a transcript because I have my own court reporter. This day, one of the attorneys hired his court reporter, and I had ended up going on some kind of wild goose chase, but I had a good relationship. I could have had the transcript. He didn't even order the transcript, so I had no way of even getting it through him. I think that was also a kind of a blockage because I'm known to keep a transcript of the proceedings. But the case revolved around Judge Huey saying, I voluntarily signed an agreement, which we all know is not true because Judge Peacock in the underlying case, this 18 CA 3553, ordered me to go and sign the settlement agreement, which I didn't want to do. I went and signed it so I didn't get caught with a contempt charge. Moreover, I have proof right here, even within the settlement agreement where I signed it under duress. That's not even in question. And if you would like, I could actually show the court that one because I think they should have it as well. And I don't think that's even up for dispute.
Well, this is related to what Judge Smith said. We can only confine our review to the record, so I'm presuming there's things that are in this record on too.
I'm thinking it should be in the record of appeal.
We don't have a transcript, so we can listen to what you say about what happened at the hearing, but we can only rely on what is in the.
But if I'm correct, the signed release should be in the record.
Yeah.
And it's signed, and it's clear that I signed it. But Your Honor, it's clear that I signed it under duress. So this notion that I voluntarily walked in and did anything.
You're referring, and I wanted to ask you what in the record you're referring to. I just want to make sure you're referring to.
The signed settlement release.
And then that on its face,
You can see where I signed under duress, on its face. In fact, for the
what's
court's,
the page of the record?
wouldn't know, but for the court's benefit, unless they was legit, I guess you can't object here, but for the court's benefit, here's the release, and it's clear that I signed it under duress. That wasn't even in question. Judge Peacock dismissed it for prejudice, and oddly enough, she turned around and disqualified herself from this because she should have been the trial judge presiding over this case. But it's clear as day that I signed under duress. I wanted no part of that settlement conference once I realized what all was going on, to include finding out that a VA attorney had some ex parte communications with Mr. Rowe. I find out when I get there, I was thinking he's somebody from the VA is there to deal with how much money the VA spent on my care, which, by the way, I'm still getting treatment for my back. But the reality of the situation is this entire situation is buoyed on misconduct. The fact that State Farm hires attorneys that will go and solicit VA doctors unbeknownst to veterans, and then have that doctor see a veteran for a compulsory medical examination and never mention to the veteran that he works for the VA, but through the intervention of God, it happened to be on a Saturday. I'm at the VA and Dr. Shim walks in, and I just noticed that he looked familiar. So when I questioned him about, hey, you look familiar, doc, and let's not forget, my name is Shagrat Urania Doss, and the VA has been handling my care since about 1993. So all over the medical records was that I was a patient of the VA.
Mr. Doss, when did you discover this?
That,
That Dr. Shim worked with the VA? Wasn't this before the mediation?
and I brought it up, and I kept trying to get the one I wanted to get. I was trying to get Dr. Shim deposed. I'm glad you brought it up because you reminded me. Mr. Rowe's firm filed a motion for protective order, and in the motion for protective order, he outright misrepresents the facts that I subpoenaed Dr. Shim. He had been served in his office. Dr. Shim doesn't show up for my deposition. The motion for protective order was granted. Well, he had an obligation, Your Honor, to withdraw that motion for protective order. One, he doesn't represent Dr. Shim. Maybe whoever was here for Dr. Shim should have been the one who filed the motion for protective order. He had no idea what I was going to ask, and it was filed hours before Dr. Shim was supposed to show up for a deposition. Now, some of this misconduct, I'm aware, and I'm not an attorney. I don't pretend to be one. But this misconduct, if I was an attorney, Your Honor, they wouldn't try this because I could get him with sanctions. But because I'm self-represented and not a bar member, I can't get him for sanctions. I can't report to the bar. But even the court had a duty, once he didn't withdraw it, to impose sanctions. because it essentially deprived me of fundamental due process. Dr. Shem should have been stricken immediately when the court found out. And we all know that 18 United States Code Section 208 is a criminal statute. Dr. Shem, Austin Rowan Basketball Professional Association, and apparently State Farm and whoever else have been doing this for some time. And I'm a little bit irritated, and I hope the court excuses me, but three Army members died this week on a set of principles that at the bare minimum, this country would do for us what they promised. And one of the things they promised was not to have to worry about having a mole inside of the VA who works to undermine not only our care, but even our recovery when we're injured due to the gross negligence in this case, because let's not forget, Chandra Tucker admitted that she saw me, had full control of her vehicle, and hit me on purpose. So even when I filed for a motion for leave to amend, that was struck by Judge Peacock. And she's not here to defend herself, but I didn't get any favorable rulings throughout the proceedings, despite the evidence of Austin Rowan Basketball's misconduct and Dr. Shem's obvious criminal violations as well. And the transcripts of the prior case, which I know you three weren't there, one of the attorneys said we had other cases, unrelated cases, where patients treated the VA, see Dr. Shem for a CME, and nobody raises an issue.
So there's the issue of the release that you signed and the $30,000 that you accepted in satisfaction of your claims. But then that would be, we've addressed that as one of the rationales for the trial court's decision not to allow you to amend. But the other rationale we haven't touched on as directly is something that, let me back up for a minute. We addressed legal issues at this court, and not you've appeared before us before. You know, we have to rely on the record and apply the law. And you have filed that this is a separate suit. This is no longer the suit. It's not a
No, yes, Your Honor. This is a separate
You
suit.
sued them.
I
right?
sued.
And then this is, well, you sued twice.
No, Your Honor. I sued Chandra and Linda Tucker.
This is your second suit. You sued, and now you're suing about the suit. And so that brings up the litigation.
Well, I'm not suing about the suit, Your Honor.
You're saying they committed fraud, and the defense that is that, well, there's a privilege. You can't premise these claims you brought based on activity that was undertaken during the course of the prior litigation.
But the prior litigation, the privilege issue would go away with the criminal activity and the misconduct. There's no privilege. You can't say I'm going to commit a crime. One, unknown to you, Mr. Dawson, even when you bring it up, we're going to pretend that you're not aware that what they're doing is criminal. And it also affects my right to fundamental due process. So we're not talking about Rule 1.540, B3 and 4. But let's just talk about the fact that
I don't recall reading anything in your brief about it.
No, my brief here is simple. It's simple that the trial court, in its well-established law, and the case is cited, that the trial court abuses discretion when it doesn't give me a chance to amend the complaint. We didn't even address the merits of the complaint. I know we don't have the transcripts, but it won't stop me from suing them again. So we're going to be right back here. But the reality of it is, I think it's just important to let the court know that what we're trying to do is we're masking criminal behavior by attorneys.
That's one of the aspects of appellate review is that you waive arguments not raised, and you didn't raise an argument, and I'm not sure what criminal activity you're alleging now, that oral argument. You don't recall in your briefs reading an argument that there was some sort of criminal exception of litigation privilege.
In this brief, or in the previous
case?
Well, I didn't recognize it. I think I said it earlier. I may have spoken a little quickly. That I didn't recognize how deep it went until, as time has gone on, become a little bit more savvy with this stuff.
Again, we have to rely on the
Right,
record.
but-
We're confined. We only have so much authority to undo what the trial court did.
Right.
We have to stay within our authority, just like the trial court has to stay within its authority.
I'm glad you said that, Your Honor, and I would appreciate the trial court had stayed within its authority and did what it was supposed to do. Once I brought to the trial court's attention in the earlier case, he filed a sham pleading. The trial court knew it. They admitted it in the trial court. So then Judge Huey, in our discussion here, he bolsters his entire argument. I wish we had the transcripts. I'll sue him again and get it, doesn't matter. But he bolstered his entire argument, one, for contract law, because he said he taught contract law. We know there has to be a meeting of the mind for contract. which there definitely wasn't, I made it abundantly clear that I was totally opposed to anything to do with that release. Judge Peacock ordered me to, which she essentially took my rights, and the court then stepped in and became a party to the litigation. She operated as co-counsel, numbering up on my 15 minutes. I'll preserve my last 5 minutes for rebuttal. I appreciate the court's time.
Thank you, sir. Now, are you both going to be arguing?
Oh, she's gonna let the court know how. Anyway.
What our plan is all appellees have authorized me, I am appellate counsel for Ms. Tucker, to represent the common arguments among all 4 appellees. And then Ms. Cabela is going to stand up and talk about the argument that is individual to State Farm, which my client has also adopted, the litigation privilege doctrine. So I guess if we are splitting this up, it would be probably, the lion's share would be my time, potentially 15. I don't know if I'm going to need 15 minutes, but Ms. Cabela has asked for 5. May it please the court, my name is Deanne McLemore and I represent one of the appellees, Ms. Linda Tucker. As I just explained to the court, in order to, be the most effective use of the court's time, I'm going to argue, I've been authorized on behalf of all appellees to argue the arguments common to them. And of course, should your honors have specific questions directed to an individual appellee, I can yield my time and that appellate counsel can come up and answer your honors' questions. And then State Farm's counsel will discuss the litigation privilege, which is a argument individual to State Farm. I just want to make the record clear, based on Mr. Doss's arguments here, there is a blending of 2 different cases that are happening in 2 different records. All of Mr. Doss's arguments on attempts to undo the settlement agreement and the comprehensive release that's at issue in this case, as well as his arguments about Dr. Shim, due process concerns, all of those arguments were already decided upon by this court in his first appeal. That was 2D223642. We had full arguments in this case. Judge Rothstein, you were on the panel as well. December 20th, a per curiam affirmance affirmed that decision. For this case, the only issue that Mr. Doss has raised is that the trial court erred by denying his opportunity for leave to amend when it dismissed his complaint. Mr. Doss doesn't contend at any point in this appeal that his complaint was sufficient under Florida law and therefore has waived his ability to do that now. As to his challenge for leave to amend, as this court has recognized, Mr. Doss cannot carry his burden on appeal to demonstrate error here because he's provided this court with an inadequate record on appeal. He's produced no evidence in the record that he's even requested this opportunity for leave, which is required to preserve the issue to bring it forth for appellate review. The record contains no written response to the motions to dismiss, no written leave to amend. He says he made an oral motion at the January 30th hearing. There is no transcript of this hearing. Even the court's order that grants all of the motions to dismiss and dismisses this case doesn't actually indicate that he asked for leave to amend or that a ruling was made and denied, that the court denied that ruling. This record is devoid of any evidence of both request and a ruling. Therefore, it's not preserved for appellate review, and this court should affirm on that basis alone. However, even looking beyond that, the denial of leave was proper, well within Judge Huey's discretion, because amendment here would have been futile. I also want to note that Mr. Doss in his brief does not argue that he could have amended his complaint to allege sufficient facts and sets of circumstances that would have made a viable cause of action under Florida law, and has waived his ability to do that here. Nevertheless, as was discussed, this court is aware this is a second suit arising from that original automobile accident against my client, Linda Tucker, as well as another individual, Ms. Chandra Tucker, who is not an appellee here today, for auto negligence. 2018 CA 3553 is that case number. At that case, Mr. Doss and my clients settled. Mr. Doss signed a settlement agreement. He signed a comprehensive release, which released all appellees in this matter. Linda Tucker, State Farm Automobile Insurance Company, and other State Farm entities and employees, Oskin Rowe, Baskill, PA, and its employees, John H. Shim, MD, Shim Spine, and its affiliated companies and employees from all manners of actions, causes of action, claims, demands of any kind whatsoever in law or in equity, known or unknown, which resulted or may result in development in the future as related to the auto accident from January 16th. This release was all encompassing. It was a comprehensive release that encompassed all existing and potential future matters as in relation. This agreement was a contract. He signed it. My clients gave the $30,000. He accepted those settlement funds. He cashed that check. And now he has to be bound by the terms of the contract. Therefore, the court was correct that in its decision to dismiss this case with prejudice, because amendment here would have been futile, he released these parties, he waived his future claims pursuant to this release and settlement agreement. And therefore, we would ask this court to affirm that correct decision. And unless the court has any questions, I can turn the mic over to State Farm's counsel for the litigation privilege. Okay. And Ms. Tucker also relies on her arguments made in her brief. Thank you, Your Honor. Thank you.
May it please the court, my name is Mihaela Kabiaya and I represent State Farm Mutual Automobile Insurance Company. I want to briefly address the State Farm's litigation privilege argument as an alternative ground for affirmance of the trial court's dismissal with prejudice. And it is State Farm's position that the litigation privilege applies in this case and would have made any amendment futile because it immunizes State Farm and quite frankly the other defendants as well for any conduct in the underlying tort action. So in our answer brief, we cited to a Supreme Court case, a Florida Supreme Court case, Echevarria versus Cole. And in that case, the Supreme Court considered an inter-district conflict that addressed the issue whether the litigation privilege applies only in tort cases, common law tort cases, or it applies to statutory causes of actions as well. And the Supreme Court decided that the litigation privilege applies across the board, not only to tort cases, common law tort cases, but to any causes of action initiated pursuant to statutes or any other origin. And then the court concluded, and I want to quote from the court's opinion, there's absolute immunity must be afforded to any act occurring during the course of a judicial proceeding, so long as the act has some relation to the proceeding. And I want to draw the court's attention to the complaint, Your Honors, which can be found at pages 5 to 19 of the record. It is clear from the complaint, even from the first page of the complaint, where Mr. Das alleges conspiracy by the defendants arising from conduct in case number 2018-3553, that is the underlying tort case. All the paragraphs beginning in the complaint from paragraphs 29 and up to 64 contain allegation about conduct by State Farm and the other defendants regarding either the mediation, either the settlement, either motion practice. So it is very clear that all the actions, causes of actions that conspiracy to commit fraudulent inducement, constructing fraud and fraudulent inducement basically stem from alleged conduct by State Farm and the other defendants in the underlying tort action. So it is our position, Your Honors, that the litigation privilege applies, and because of all of the allegations concern some unidentified motions and statement made by either counsel for Dr. Shim or by Mr. Rowe, and by conduct during mediation of the parties, the stipulation signed by the parties, the settlement reached by the parties, and the release signed by Mr. Doss. So clearly, we ask this court to affirm based on the litigation privilege. And it is important to note that no set of facts that Mr. Doss could have pled in an amended complaint, and he doesn't say he could have pled any, concerning the conduct of the defendants during the tort case could have led to a plausible cause of action that would not be barred by the litigation privilege. So ultimately, Your Honors, we want to point out that, as my colleague did, that Mr. Doss signed a settlement agreement, had a mediation agreement and the settlement release, and he released each and every one of the appellees in this case and additional entities that are not subject to this lawsuit, but he released State Farm and any associated entities. He released Linda Tucker, he released Dr. Shim and the Shim Spine, and he released Mr. Rowe and his law firm. And this court has upheld that release in the appeal that was affirmed per curience previously. So if the court has no questions, I will rest on the arguments in the written brief and on the arguments of my colleague that she made here today.
Thank you, Ms. Cavalier. Mr. Doss, you have your report back today?
Thank you, Your Honor. It was interesting as I sat back and listened to counsel's arguments. No one has ever disputed that Judge Peacock ordered me to go to Mr. Rowe's office and sign that release. Otherwise, I don't go there. She ordered me to. And in fact, the order stated if I did not sign it, it would have the same force and effect within 10 days as if I did sign it. Furthermore, unless I'm missing something, they can't argue privilege when it's criminal conduct or fraudulent conduct. And fraud specifically is simple. If he knowingly gets the machinery of the court moving in a direction under a false pretense, he's committed fraud. And he's an attorney. Now, I may be able to get away with making a few mistakes, but we know attorneys can't. I've seen the Supreme Court disbar attorneys for it. And we all know that they did. They built this entire argument on fraudulent conduct. I actually appreciate them coming in here to admit it. No one's disputed that I've said anything that isn't accurate. No one, not in their appellate briefs or anything else. They're hoping that this court, and that I don't sue them again, which is not going to happen, lets them get away with not only just abhorrent behavior, but criminal activity as well, perpetrated against veterans of the United States military. That's what they want. And had I not raised it in the previous case, because they just resurrected it, we'd be somewhere totally different. The transcripts in the previous case they're clear. No one's going to come up here and say under oath that Mr. Doss didn't raise an objection to Judge Peacock forcing him to sign the release. I even brought up the mirror image issue. There's no competent substantive evidence to show that Mr. Doss did not, in the previous case, object vehemently against having to sign something. That's in the record. And it's also indicated by my signature under duress on the release. Now, if they want the $30,000 back, we can talk about that too. But if that's what they're basing this on.
Mr. Doss, just want to point out another issue. Where in your brief did you elaborate in any degree at all or mention that you signed the release under duress?
In this brief, I didn't. In the previous one, I didn't. I believe also they brought up that you all did PCA. No, in this one, I didn't. I thought I made that clear. No, in this one, it's not.
That we have to go on the briefs and the record in this appeal, and your opposing counsel raised the issue of the release as justifying.
But the release is signed under duress, Your Honor.
Where in your brief did you argue that?
No, I did not in this one. This one is simple. The trial court abuses
We have to
discretion by
follow rules,
releasing.
just like you're saying, the trial court never has to follow rules, we have to follow rules, we only have the authority.
I understand
Address
that, Judge
these
Atkins,
raised.
and I appreciate you giving me a little variance. No one is disputing, and I'm still within the statute of limitations. So if we're gonna argue this other issue, we can do that at another time. And by the way, I did ask this court to reconsider that PCA, given the new set of circumstances and the fact that the trial court had no jurisdiction over the unplayed issues, and they essentially resolved unplayed issues. I did not sue State Farm, Austin Road Basketball, Dr. John Shim Spine of the United States government, which I will now. I only sued Chandra Tucker and Linda Tucker, and she did say something that was correct, for the incident that happened on January 16, 2017. Everything else happened after January 16, 2017. Everything happened after that day. The only thing that happened on January 16, 2017 is that Chandra Tucker, and they filed a notice of negligent admission, intentionally ran her vehicle into the rear of IKEA. That's what happened on January 16, 2017, and I'm saying that because she said it in our deposition. So this is nothing's unclear to me. And I'm a little bit stunned by the fact that attorneys have walked in here and admitted that they conduct themselves this way. Now, I don't want to make this a biblical issue, even though you talk about me, God bless the United States. The Bible says in Luke chapter 11:45, woe unto the lawyers, for they lay men with burdens grievous to be borne. They touch the birds with not one of their fingers. It goes down further and says, woe unto the lawyers, for they take away the key of knowledge, entering not in themselves, for those that try to enter, they hinder. And that was said by someone much greater than me. The Messiah said that. But we're standing in here about this issue. And whether the court does it or not, I just wanted to make sure I had my opportunity to speak to this. And I appreciate them being so candid as to their despicable behavior. And I'll wait for this court to rule not only on this one, but on my request for reconsideration en banc to the last decision and for a written opinion. And I'd like to have a written opinion in this case as well to give me an opportunity to hopefully go to the Supreme Court and have them at least address this issue of this kind of behavior, because the fraudulent, the privilege issue, the attorney-client privilege cannot prevent the disclosure of communication made in contemplation of a crime or the perpetration of fraud.
Mr. Doss, thank you, sir.
Thank
You're
you
out
so
of
much.
time. Here for the last case. Okay.